The mother sentenced to death facing a firing squad or gas chamber, electric chair.
This is about a series of very poor choices by the defendant. And because of these, now we have a child that is
This man just told me you're trying to give me 13 years.
Kayla Sadowski's murder in Monroe County shocked the community when authorities uncovered a disturbing plot involving 6 individuals. The crime was allegedly planned as a wedding gift for Stephen Bales, the group's leader. Sadowski, who had previously dated Bales, was lured to an abandoned location under pretenses. Once there, she was fatally shot, and her body was left in a remote area while the group attempted to cover up the crime.
A state policeman woke me up and told me he had found my daughter and she had been murdered.
The investigation took a major turn when Alexander Fecco, one of the conspirators, cooperated with authorities. His testimony exposed the roles of the other 5 individuals and led to their arrests.
You should have alerted somebody to this ridiculous plan, and you didn't do that.
The judge handling the case called the plan ridiculous, emphasizing how Bales manipulated the others into carrying it out.
You can't just eliminate someone because they irritate you or gather a bunch of sycophants to follow you in this ridiculous plan.
Judge called this a ridiculous plan.
It was a ridiculous plan.
But he also said that your son was the leader.
I don't believe that. I don't believe that at all.
During sentencing, Bales received life in prison without parole after a short jury trial found him guilty. His newlywed wife, Narina Bales, was sentenced to 13 to 30 years for her involvement. Sierra Bemis, who acted as the lookout, was sentenced to 18 to 30 years.
Anybody would know that when they're told to go dress in black, that's the time to put the brakes on.
He was the guy who came forward to help break this open.
Alexander Fecco, who later helped authorities but also attempted to dispose of the murder weapon, received 5 to 10 years. 2 additional defendants also faced prison time, ensuring all 6 conspirators were held accountable. The final conviction was secured in March 2024, marking the end of legal proceedings. Sadowski's family expressed their grief, struggling to understand how former friends could have turned against her so violently. Authorities credited Michigan State Police and Monroe County investigators for their work in solving the case. Sanaya Frazier stood in court, charged with manslaughter in the overdose death of a girl. The prosecution argued that her actions directly led to the tragedy, while the defense insisted it was an unfortunate accident.
The purse was directly next to see where the baby would have been saved. Sanaya produced a pill that she said had been in her purse, that there were several that were in her purse for the purpose of trying to help, figure out what was going on with this baby, and said that they had seen the baby playing in the purse the night before.
Testimony revealed that Frazier had left a purse containing fentanyl-laced pills beside the girl who was sitting in a chair. At some point, the girl got access to the purse. Frazier and her sister saw her playing with it and intervened, but the purse was not secured properly. Hours later, the girl became unresponsive and died. During the hearing, Frazier became emotional as her attorney pleaded for the charges to be dropped.
At the end of the day, kids getting into every single nook and cranny is unreasonable for us to constantly be worrying about 24/7. But when we do see them possibly doing something, what do? We take care, we separate. And that's what they did.
He argued that no caregiver can anticipate every possible danger, emphasizing that when Frazier noticed the girl with the purse, she took action. However, the prosecution countered that the case was not about an accident, but a series of reckless decisions.
This is about a series of very poor choices by the defendant. She chose to keep the illegal narcotics. She chose to keep them in not a pill-safe container. She chose to keep them in her purse that was open. She chose to keep that person within reach of a child. And because of these, now we have a child that is dead.
They pointed out that Frazier chose to keep illegal narcotics, chose not to store them securely, and chose to leave them within reach.
Your client created this danger to that baby, and but for that danger created by your client, that baby he would still be alive.
Judge Jennifer Liebson rejected the defense's argument, stating that Frazier had created the dangerous situation and that, had she acted differently, the girl would still be alive. She ruled that the case would proceed to a grand jury. Frazier remains in custody on a $250,000 bond as the legal process continues. A peaceful night in the River Club community of Bradenton took a violent turn when two masked men forced their way into a home. The homeowner, confronted with the intruders, reacted swiftly, leading to a deadly encounter. Jorge Nestevan Flores Toledo, 27, was fatally shot, while his accomplice, 39-year-old Michelle Soto Mella, managed to escape. Authorities responded quickly, securing the area and launching a search for the second suspect. Soto Mella was soon captured and charged with armed burglary.
I just want to say that I never had any firearms or killed anybody.
I don't want you to interpret any facts of the case. Sir, I don't want you to talk about the facts of your case at all. Do you have any questions?
Investigators revealed that he had entered the U.S. from Chile on a visa that had expired months earlier. Before the break-in, he had been staying in a Tampa hotel.
Allegedly staying at a hotel somewhere in Tampa, and then decided, him and his partner decided that they were going to travel to the River Club area and commit this burglary.
Law enforcement determined that the homeowner acted in self-defense and would not face any charges. Manatee County Sheriff Rick Wells praised the homeowner for protecting his family and property.
I don't think he was expecting to confront someone face-to-face when he entered that room, but he did, and he reacted the way that you would hope all of us would react when you have someone that's threatening your home.
The shooting took place the night after Christmas, leaving many residents shaken. Some reported hearing shots before seeing multiple police cars and an ambulance arrive at the scene.
We were just watching a movie and my dad was by the window and he goes, I'm pretty sure I just heard some shots. And then next thing we know, we see about 20 police cars and an ambulance right down there, and everybody went out to check it out.
As the investigation progressed, a third suspect emerged. 32-year-old Aldo Jean-Pierre Armijos Casillo had managed to flee Florida, but was later tracked down in Colorado while attempting to escape to Mexico. Authorities charged Armijos Casillo with felony murder, as Florida law holds accomplices accountable if a crime results in a death. Soto Mella remains in custody, awaiting trial for his role in the crime. Z. Duffy's legal troubles began when federal authorities charged him with 7 counts of drug distribution and 1 count of being a felon in possession of a firearm and ammunition. After an investigation linked him to illegal drug activity and unlawful firearm possession, he pleaded guilty in February 2019. During his sentencing hearing in June 2019, Duffy appeared before Judge Jim Maraldi, visibly emotional as he pleaded for a lighter sentence.
Your Honor, I was doing good out there. I really was, Your Honor. I made it off the SAMS program. You told me, you gave me 30 days to get my system clean. I came back here on my system clean. I did all the calls this lady asked me to, and she granted me permission to not even have to call the SAMS program no more. I was doing good, Your Honor. I really was. I was doing good. They just made me look like a monster. The person they just made me out to be, Your Honor, I'm scared of that person that they just tried to make me out to be. Your Honor, I was doing good out there. I was not selling drugs. I wasn't doing none of that. I wasn't. I was trying to get my life on track, man. And this man just told me you're trying to give me 13 years. I'm having a heart attack. Your Honor, I'm sorry. Please don't sentence me to 13 years, Your Honor. Please don't. I'm not a monster. I'm not a monster. I'm telling you.
He expressed remorse and urged the court to consider his circumstances.
Who was driving that car the other day when the police were chasing you?
I was driving.
Well, I don't know anyone in this courtroom that would lead the police on a chase, ram their cars, and put people
I
in
did
prison.
ram their car. That's that case. That's what I'm asking you. Can you not look at the pending cases, please? I haven't even had preliminaries on none of that. I'm asking you, Your Honor. Can you reschedule this or something, Your Honor? Please don't sentence me to 13.
I think I've had plenty of time to observe how you would behave after you left prison. and you have not respected the court's orders. I gave you strict orders as to how you were to comport and conduct yourself, and you have not done that, even apart from the allegations about these pending charges. I hung significant prison time over your head, and I made it very clear to you that these would run consecutive, and that you had to follow very specific rules to stay out of prison, because the 8 cases you had in this courtroom showed to me that you were a thug, a potential menace to society. But because of your age and because of the family support you presented, I gave you an opportunity. I gave you more than one opportunity. I gave you more opportunities than maybe I should have, because look at where we're here today. You put people's lives at risk, and I'm not going to allow that to happen anymore under my watch. So you've had your chance to say what you wanted to say, but you...
The judge denied Duffy's appeal for leniency, emphasizing the threat he posed to the community and his repeated disregard for opportunities to change. Despite multiple chances, he continued down the wrong path, leading to a 270-month, 22.5-year federal prison sentence. He appealed his sentence, arguing that he was misclassified as a career offender and that the court miscalculated his offense level. In July 2020, the Sixth Circuit Court of Appeals rejected his claims and upheld the sentence. In November 2022, he filed a motion under Rule 60BE to reopen his case, but the court denied it, advising him to seek relief under 28 U.S.C. Section 225(5). His request for free court transcripts was also denied. He remains incarcerated with the option to pursue further legal action, though his previous appeals have been unsuccessful. Nicholas Meeks became the focus of a tragic case following a DUI crash in Greenville County that claimed 4 lives. The incident occurred on New Year's Eve when Meeks, allegedly under the influence, collided with another vehicle, causing a fiery crash that resulted in fatal injuries to all 4 victims. Authorities arrested Meeks shortly after the accident, charging him with 4 counts of felony DUI resulting in death and driving under suspension. During the bond hearing, family members of the victims spoke about their devastating loss, emphasizing that the tragedy could have been avoided if Meeks had not chosen to drive while impaired.
Hi, Your Honor. My name is Andy Ellis. I'm here on behalf of my best friend, Jeanette Ross. She was the mother of Audrey Ross, who was the driver of the car. She lost her only child and her best friend, and Audrey was bright and compassionate. You made a decision yesterday that affected many lives. You got into a car after drinking. Oh, yes.
I would have appreciated to address the court.
Okay, I'm sorry. Okay. So he made a decision yesterday that affected many lives and got into a car drinking and decided to drive. His actions took the lives of 4 people. Every person in that car had value and had a family that loved them. They will never be able to see them, talk to them, or touch them again. His life is also valuable. He has a family, and this will affect him and his family as well. Jeanette, Audrey's mom, loves the Lord God with all her heart, and she will forgive him and pray for him, but his actions should have consequences. And I hope and pray that he will learn from these actions, and I hope and pray that the next person that drinks and thinks they can drive will learn from his actions and not do it. Thank you.
One speaker, Andy Ellis, addressed the court on behalf of Jeanette Ross, the mother of Audrey Ross, the driver of the other vehicle. She described Audrey as a bright and compassionate individual whose life was cut short due to Meeks' reckless decision.
Good afternoon, Your Honor. I'm Donasia Nathan, the victim's advocate for Highway Patrol. This is a very unfortunate incident, and it could have been avoided had the defendant chose not to disregard the law by drinking and driving at an accelerated speed. We ask on behalf of the state and the victims' families that there is no bond. However, if you are inclined to set a bond, we ask for the highest cash or surety bond, as well as GPS monitoring. Your Honor, I would also like to go on record and say that he has a criminal history, and this may not have been his first incident with driving under the influence. So we do ask that because these losses are important to the families and friends and loved ones of our victims, that you take that into consideration. Thank you.
Thank you very much.
The victim's advocate from the Highway Patrol urged the judge to deny the bond, citing Meek's prior DUI conviction and his history of driving under suspension. It was revealed that Meeks had been found guilty of DUI just months before, in March 2024, yet had continued to drive despite legal restrictions.
Okay, Sergeant, would you like to represent the state?
Sergeant Chad Thompson, just like Ms. Denisha spoke about earlier, he's got a pass. He's also been charged with DUI once before. He's also driving under suspension. So these are that he took into consideration, chose to drive and do the same thing that he once done, which is obviously a whole lot worse than what the original one was. So we just asked for no bond be set on him, and I'll keep the victim's family obviously in my prayers. And if I can do anything else for y'all just let me know.
Okay, thank you, Sergeant. I did look at the defendant's criminal history before I came in here. He was in fact found guilty of DUI back in March of this year, and he is driving under suspension, charged with that. And obviously if he had not been driving, this never would have occurred. I'm going to give you a bond of $653 on the DUS, and I'm going to no bond you on the felony DUI. You will be appearing in front of a circuit court judge at a later date, at which time you very well might get a bond. I don't know if you'll be able to meet it or not, but that will be held at a later date. The victim advocate will keep everybody apprised of anything further down the road. He does have a right to a preliminary hearing. He might choose to go that route, and you would be available to be present then if you chose to do so. Sorry for your loss, and I appreciate you being here today.
During the hearing, the judge reviewed Meek's criminal history and ruled that bond would be denied for the felony DUI charges, ensuring he remained in custody. However, a $653 cash bond was set for the driving under suspension charge. The judge acknowledged the victims' families and assured them they would be informed of future court proceedings. Meeks is currently being held at the Greenville County Detention Center, awaiting his next court appearance. On July 28, 2015, Adriana Young, 24, lost control of her vehicle and crashed into a home in Amherst Township, Ohio, killing Deborah Majkut and injuring her son. The tragic incident led to criminal charges against Young, as authorities determined her actions warranted legal consequences.
Required to do better. The cases of death due to negligence behind the wheel of a car are the most vexing cases facing the judge. The immensity and unfairness of the loss is immeasurable. But the nature of the behavior being punished here is not the usual criminal behavior, where someone intended to cause harm or was armed with a weapon in the course of criminal conduct, where death or serious injury.
In 2017, she was convicted of aggravated vehicular homicide and sentenced to 4.5 years in prison. While some viewed the sentence as appropriate, others, including Majkut's family, felt it was too lenient given the severity of the outcome. After serving 8 months, Young petitioned for early release, arguing for a second chance. In January 2018, Judge James Moraldi approved her judicial release, citing her good behavior in prison and low risk of reoffending.
Most, if not all, the letter writers assume that Ms. Young was driving under the influence of marijuana or alcohol. And this fact is the main argument why they think my sentence initially was too lenient, and the consideration of judicial release a travesty of justice. I heard today that the victim understood that the defendant had been committed 3 or 4 acts of operating a vehicle under the influence. This is not evidence that was ever presented to me, because I do not believe, and the state presented me with all the evidence of her past criminal behavior. That was not accurate. It was partially accurate. The defendant was on probation for one OVI offense in 2014, her first and only offense. The evidence in this case did not prove that she was under the influence. Indeed, the defendant was never even indicted for driving under the influence, because the prosecution admittedly stated it could not prove it. Although trace amounts of marijuana were found in Ms. Young's system, it could not be established by the law that whether she had even smoked marijuana that day, or whether these amounts were from use a day or so before. She was only charged with a minor misdemeanor possession, and such possession was never offered to prove that the defendant was driving under the influence. Where the prosecution does not even have evidence to charge the defendant with driving under the influence, let alone prove it to be the case, a judge must not let the fact that others believe this to be the case influence a decision about the appropriate punishment or whether or not judicial release should be attempted.
He acknowledged the grief of Maikut's family, who strongly opposed the decision, but ruled that Young had met the legal criteria for release. As conditions for her early release, Young was placed on 5 years of community control, and her driver's license was permanently revoked. The ruling stirred controversy, with critics arguing that justice had not been fully served. Robert Brooks, a 43-year-old inmate at Marcy Correctional Facility in New York, became the center of a legal and public controversy following his death while in custody. Brooks had been serving a 12-year sentence for first-degree assault and was transferred to Marcy shortly before the incident. Known for his interest in music and education, he earned his GED while incarcerated and was working toward rehabilitation. Upon arrival at Marcy, Brooks was taken to a medical examination room where he appeared injured and restrained. Body camera footage, later released by investigators, showed correctional officers interacting with Brooks in a manner that raised concerns about the use of force. Shortly after, Brooks became unresponsive, prompting efforts to move him back to the examination table. He was later pronounced deceased at Wynn Hospital in Utica, New York. A preliminary autopsy cited asphyxia due to neck compression as the cause of death. The New York State Police launched an immediate investigation, collecting evidence and executing multiple search warrants. The case quickly gained national attention, with Governor Kathy Hochul ordering the termination of 13 officers and 1 nurse involved in the incident. The FBI also opened an investigation. Underscoring the seriousness of the case, a grand jury indictment followed, leading to 6 correctional officers being charged with second-degree murder, manslaughter, gang assault, and tampering with evidence. Those indicted included Nicholas Anzalone, Anthony Farina, Matthew Gallagher, Christopher Walrath, and David Kingsley II. Days later, a 7th officer, Nicholas Kiefer, was arraigned on similar charges. One of the defendants, Nicholas Keffer, appeared in court for arraignment, where he formally pleaded not guilty.
Okay, thank you. This is the matter of people against Nicholas Kiefer, indicted 25035, on for arraignment today. And Mr. Curley, I understand you're appearing of counsel to Attorney David Loncoretta, who's been retained in this matter. Is that correct?
It is, Judge.
All right. So that's your name, Nicholas Kiefer?
Yes, sir.
How old are you, Mr. Kiefer?
33.
Mr. Kiefer, you're here today because the grand jury of Oneida County returned an indictment against you. You do have to be arraigned upon that. Counsel, you may arraign.
Thank you, Your Honor. The people of the state of New York, by indictment number I-2025-035, the grand jury of the county of Oneida, by this indictment, accuses Nicholas Kiefer of the felony crime of murder in the 2nd degree. Defense counsel, do you waive a further reading of the indictment? Yes. Your Honor, I'm providing defense counsel a copy of this indictment as well as the people's standard pretrial notices, one of which is our intent to use statements allegedly made by the defendant. The people are also providing a disc with recorded statements from the defendant. Defense counsel, do you acknowledge receipt?
I do. I acknowledge receipt of those documents and the disc. I waive any further reading, Judge, and I plead not guilty on all charges.
Very good. A not guilty plea is entered on the defendant's behalf. It's the court's intention at this time, along with the other cases, to adjourn this matter to March 31st. That will be at 9:30 a.m. for a pretrial conference. Would either side want to be heard on the question of bail?
Yes, Your Honor. People would like to be heard.
Go right ahead.
Your Honor, the co-defendants in this case have previously had bail set at $100,000 cash, $250,000 bond, $1 million partially secured bond. The people believe that the defendant should have the same amount set on him, along with Mr. Anzalone, Kingsley, Frena, and Walrath and Gallagher. And we would ask that he provide the defense with his passport, and the defense allow the people in the court to be notified when that has been done.
Thank you. Mr. Curley, first of all, does your client have a passport?
He, not with him, Judge. He has one, and we'll see if it gets to the court.
Yeah, it'll be conditioned that he turn that in. Did you want to be heard on the topic of bail, Mr. Curley?
No, Judge, we're prepared to go forward on that basis. We have the bail bondsman here.
Just 1 second. Madam Clerk, you can pass that over to Mr. Curley, please. The court has considered the arguments of counsel here this morning, considered all of the statutory factors, and noting in particular that the defendant, if convicted of the top count, could face as much as 25 years to life in state prison. Bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. And with that, I understand our bondsman has some paperwork.
Would you like me to have it signed, Your Honor, or would you like to see it?
Let me take a quick look at what you got. Appearing before me now is bondsman J. Bernardo. Mr. Bernardo, do you swear the truth of the content of your bail undertaking and affidavit?
I do, Your Honor.
I have before me a proposed bail bond in the amount of $250,000. I understand you're asking to be released upon this. Is that correct?
Yes.
All right. You understand what your number one obligation is under this bond?
Yes.
What is that?
Hear my court case.
Come back to court. Exactly right. So some things to understand. First of all, you do have a right to be present at all stages of proceedings in your case. If for some reason you did not come back to court as required, then a warrant would be issued for your arrest. The bail posted by way of this bond, that would be forfeited and lost, and you would then face a new felony charge. That's known as bail jumping. And your case could proceed in your absence. That means you could be tried in your absence, and if you were convicted, sentenced in your absence as well. Do you understand that?
Yes, sir.
I've received now a document entitled Parker Warning, which outlines in writing the same warnings that I just gave you. Can you confirm for me that you signed this document here in court after you reviewed it with your attorney today?
Yes, sir.
Court is signing and approving the bail bond. Thank you. Mr. Kiefer, you are due back in this court on March 31st at 9:30 a.m. for a pretrial conference. Keep in touch with your attorney in the meantime, and that passport is to be turned in promptly.
Thank you, Your Honor.
Prosecutors requested that Kafir be held under the same bail conditions as his co-defendants, with bail set at $100,000 cash, $250,000 bond, or a $1 million partially secured bond. Additionally, Kafir was required to surrender his passport, a request his defense team agreed to comply with. The judge upheld the requested bail conditions, citing the severity of the charges and the potential penalty of up to 25 years to life in prison. Kafir later posted a $250,000 bail bond and was released under court supervision, with the requirement to appear for all future proceedings. The court scheduled a pretrial conference where prosecutors are expected to present evidence surrounding Brooks' death, while the defense prepares its arguments. The case has sparked public outrage and demands for reform in the New York prison system. Advocacy groups have called attention to systemic issues within correctional facilities, arguing that greater oversight and accountability are necessary. In response, state lawmakers proposed new measures to expand the New York State Commission of Correction and introduce independent investigators to review similar incidents. Eligio Bishop, widely known as Nature Boy, led a controversial group called Carbon Nation, which promoted polygamy, and self-proclaimed spiritual enlightenment. Through social media, Bishop attracted followers who believed in his teachings, but beneath the surface, allegations of manipulation, abuse, and control painted a far darker reality. In April 2022, authorities arrested Bishop in DeKalb County, Georgia, after a former follower accused him of assault and releasing explicit content without consent.
I wasn't able to go. I felt like I couldn't. I felt powerless. And he kept telling me that he wanted to just do it one more time, just one more time.
The victim alleged that after trying to leave the group, Bishop forced her to stay and later humiliated her by sharing private videos online.
What the defendant did with that power, the answer to that, the evidence will show, is yes. Nobody said no to the king.
By early 2024, Bishop's trial had begun. During court proceedings, tensions escalated when he attempted to fire his attorney, Robert Booker, in the middle of the trial.
As far as counsel, you either proceed with Mr. Booker or you represent yourself, period. You do not get to stop the trial to hire a new attorney. Number one. Number two, COVID. I've discussed this with counsel. We've mentioned it to the jurors. Everybody is fine with going forward. We have masking in place. We have provided you with a mask. We have hand sanitizer. COVID's been going on for 4 years, folks. We got to figure out how to live with this. We are way more than 5 feet apart, and the CDC guidelines are in the process of changing anyway with respect to the isolation rules. Well, they haven't changed yet. They are in the process of changing them to eliminate the isolation requirements and just to require masks. I am wearing a mask. I will wear a mask throughout the entire trial. So that if you're not comfortable with that, and you want to sit in lockup during the course of the trial, that is your right. And that will be considered a voluntary absence from the proceeding.
Will I be able to hear what's going on?
Nope. There's no feed back there. Nope, you wouldn't be able to hear it. So it's up to you.
So,
2 choices, sir. Proceed or just go in the back. That's it.
and this is on record?
Everything, yes. Everything is on record. Everything I'm saying is on the record. So the appellate courts can hear it. If they think I handled it improperly, they'll have their discretion to do whatever they deem appropriate. So you need to decide now what you're doing. Do you want to stay in the courtroom for the remainder of the proceeding, Mr. Bishop, and participate in this trial?
Participate?
Yes. Testify, not testify, be here when witnesses testify.
So whether I'm here or not, this is going to go forward?
Yes, that is correct. That is correct.
Who will be representing me if I fire my lawyer?
You. You will represent yourself. Those are your interests.
And if I represent myself and not choose to be in the court, then who will represent?
Nobody. Nobody.
Okay, well, I would have to fire my attorney and not be in court.
Okay. All right. So that means, if that is the case, you want to fire Mr. Booker and you want to remain in the courtroom. You want to remain in lockup, correct?
Yes.
Okay, so that means there will be no, if you fire Mr. Booker, that means no witnesses are going to testify on your behalf. You will be presenting no evidence, and we will move right into the closing arguments.
So are you saying that?
In a heated exchange, Judge Stacey Heydrich made it clear that he had only two options: continue with his current lawyer or represent himself. She firmly denied his request to pause the trial to hire a new attorney, emphasizing that legal proceedings would move forward as scheduled. Frustrated, Bishop questioned the fairness of the decision, even suggesting that if he refused to appear in court, he would have no legal representation. The judge explained that in his absence, the case would continue without a legal principle known as voluntary absence. Despite the courtroom drama, the trial pressed on, with former Carbon Nation members taking the stand. Witnesses described Bishop's control over the group, enforcing strict obedience, restricting movement, and punishing those who defied him. The prosecution argued that Bishop had built a manipulative and coercive environment, using his influence to exploit followers emotionally and physically.
You know, I would have been inclined to exercise some discretion had Mr. Bishop shown any remorse, guilt, or regret throughout this process. And I saw nothing during the trial but for him laughing and cutting up and looking shocked and surprised at all of the testimony. Mr. Bishop, you're a master manipulator and probably the classic definition of a narcissist like that I've ever seen. You took advantage of these folks who were essentially lost souls, looking for some guidance, looking for some connection, or looking for some comfort. And you were able to fill a void for them for some reason. But in the process, you completely took advantage of them and have caused potentially, I hope not, but potentially irreparable harm. I hope that all of the victims will be able at some point in time to recover from this and to find some type of peace in their lives. And maybe the verdict will help in that regard. But I hope you all are able to move on at some point and find some peace, whatever that is for you. So with that, I am going to follow the recommendation of the state in this case. On the rape, he'll be sentenced to life without the possibility of parole, followed by 10 years consecutive for the false imprisonment. And on the internet porn, count 3, 12 months to serve, concurrent to the false imprisonment. The internet porn I'll run concurrent to the false imprisonment. Internet 5 years, so it's 12 months on count 3, 5 years on count 4, and 5 years on count 5. All of that will run concurrent to the false imprisonment, but the false imprisonment is consecutive, so it's life without parole plus 10 years. And hopefully he will never be able to take advantage of anybody else again.
After reviewing evidence and testimonies, the jury found Bishop guilty of assault, false imprisonment, and illegal transmission of explicit material. During sentencing, Judge Heydrich denounced his actions, describing him as a master manipulator who abused his position of power. Bishop received a life sentence without parole, plus an additional 10 years. In August 2019, a tragic case in Colleton County, South Carolina, brought national attention to the issue of child neglect. Christina Pangalangan, a girl with a brain condition, was nonverbal and had limited mobility, relying entirely on others for her care. Her mother, Rita Pangalangan, and her boyfriend, Larry Eugene King Jr., were later charged with severe neglect that led to heartbreaking consequences. On August 15, 2019, Rita and Larry left Christina inside a parked Volkswagen Jetta outside Larry's home. The vehicle remained in direct sunlight for nearly 6 hours, with temperatures inside reaching dangerous levels. Surveillance footage later revealed that Rita and Larry spent most of this time indoors, engaging in personal activities without checking on Christina. 4 hours later, they realized they were locked out of the car. Instead of seeking immediate assistance, they drove to Rita's house to retrieve a spare key. By the time they returned and unlocked the car, Christina was unresponsive. Medical responders later recorded her body temperature at 109.9 degrees Fahrenheit, a dangerously high level. Investigators also discovered both Rita and Larry had methamphetamine in their systems, raising concerns that substance use may have played a role in their decisions that day. During the trial, prosecutors presented evidence that Christina's suffering was not an isolated incident, but part of a long history of neglect. One of the most significant testimonies came from Lindsay Lewis, a former student of Rita, who had babysat Christina a year prior. In August 2018, Lindsay visited Rita's home to learn about caregiving for people with special needs as part of her nursing aspirations.
So you had to change your diaper, What type of food did you give her?
I was told to give her Ensure nutrition drinks.
Anything else other than that?
No, not at the time.
All right, so you go over there on the second with an idea of learning how to take care of her. What happens after that? About what time do you get there, by the way?
I believe it was about noon. Maybe noon, 1 o'clock maybe.
All right, so what happens after that?
Well, I just got there and we went over the routine pretty much, and then Rita asked me if I would watch Christina while she went on a date with Larry.
Was that Larry King?
Yes, sir, her boyfriend. As of my understanding.
What time did she ask you to go, if you would watch it?
What time?
Yes, in other words, you got there about noon, you went through the care. About what time did she ask if you'd watch it?
I believe it was like around 5, 6 o'clock.
And did she?
Yes, sir.
Okay. And tell me about that. She left the house, I'm assuming, sometime around that afternoon?
Yes, sir. I would say about like around 5, 6 o'clock. That afternoon, she left.
Was anybody else there to take care of Christina?
No, sir.
It was just you?
Mm-hmm.
Had you taken care of Christina before?
No, sir.
This was on what day?
The second.
August the 2nd.
Yes, sir.
What day was that?
A Friday.
Did you see Rita Pangalayan again?
Not until Sunday afternoon.
After she went on a date with Larry, did she say, I'm gone and I'll be back Monday or anything like that?
She said that she texted me later that night to check on Christina. I would say about 9:30, 10 o'clock. And then she said she would be back the next morning on Saturday to go grocery shopping and stuff like that, but she never came. And
were there groceries in the house?
No, sir.
Just the insured drinks?
Mm-hmm. And I think there was a pitcher of Kool-Aid in there, maybe in the fridge.
Right. So did she come back the next day? That
No,
would be,
sir.
I guess, the
Saturday.
Saturday, correct?
Mm-hmm. Saturday.
Did she come back Saturday?
Mm-mm. No, sir.
Did she call in?
No, sir.
Were you able to get in touch with her?
Through Facebook, I think it was.
I'm sorry?
Through Facebook, I think it was.
Did you talk to her again Rita, after that?
After Saturday?
Yes.
Not until Sunday, when she said that she would be, that Larry would drive her back to the house because she did not know how to drive his truck, and that he got sick with food poisoning. So that's why she was gone taking care of him.
At any point in time, did she call to ask if it was okay if you took care of the child?
No, sir.
Didn't hear from her after she called to check in Friday night?
No, sir.
Did you ever, by the way, did you see Larry later on?
Later on, when?
That next day?
Mm-mm. On Saturday? No, sir.
Or Sunday?
Sunday? No, sir. I know he was out there. I could hear music or something. I know somebody was out there. And I'm guessing it was him dropping her off.
Yes. I would throw that. My real question was, did you ever find out if he was actually sick?
Sick? No.
No what?
No, sir. I did not find out if he was actually sick.
Okay. And then, when did you, in fact, see Rita again?
Again, when? Oh, that would be Sunday.
Okay. Sunday, about what time was that?
Then the afternoon. I would say 5, 6 o'clock maybe.
Tell me also, did you also put the child to bed? Did you also put Christina to bed?
Mm-hmm. Yes, sir.
Did you see anything unusual?
Yes, sir, I did.
What was that?
I came later to find out it was bed bugs.
Shortly after she arrived, Rita unexpectedly asked her to stay overnight, saying she had plans with Larry. Lindsay agreed, assuming Rita would return the next morning, but she never did. Instead, Rita sent a brief message saying she would be back after buying groceries, but never followed through. The next day, Rita texted again, stating Larry was unwell and that she had to stay with him. For nearly 2 days, Lindsay cared for Christina alone, without enough food or clear instructions. Uncertain of what to do, she continued waiting. When Rita finally returned on Sunday afternoon, Lindsay noticed unsanitary conditions in the home, including a bedbug infestation where Christina slept. Additional testimony came from a former roommate who stated that Rita had previously suggested leaving Christina in a car with the windows down, implying she had done it before. These testimonies supported the prosecution's argument that Christina's death was not a one-time mistake, but the result of repeated negligence. The trial began in August 2023, with the prosecution arguing that Christina's passing was preventable and caused by years of neglect. The defense countered, claiming that while the incident was tragic, it was not intentional. They argued that Rita and Larry did not mean to harm Christina, but had simply made a series of poor decisions. Despite these arguments, the jury found both Rita and Larry guilty of murder and inflicting great bodily injury on a child.
It doesn't help me clarify in my mind who is the most culpable out of this situation, or are they equally culpable? Whose conduct was the most extreme? The mother who abandons her child in that setting and does nothing to rescue the child, who chooses Mr. King and her own pleasure over the child, or Mr. King, who throws the child, or he didn't throw it, places the child in the back of the car and shows no concern, compassion, or anything for the child, and in effect joins with the mother in the treatment of the child. Though it wasn't his child, he initiated his role in it when he placed the child in the back of the car and when he did nothing to get the child out of the car.
During the sentencing, the judge expressed difficulty determining which defendant was more culpable, ultimately concluding that Rita's actions were worse, as she was Christina's mother and had repeatedly prioritized her own interests over her daughter's well-being.
All right, Mr. King, if you'll come around for sentencing. King is sentenced to the court on the offense of murder that you be committed to the State Department of Corrections for a period of 32 years. Great bodily injury, the sentence is 20 years. Sentences will run concurrent with credit for any time that you've already served.
Thank you.
Thank you all.
Larry King was sentenced to 32 years for murder and 20 years for inflicting great bodily injury on a child, with sentences to run concurrently.
Ms. Panalangan, a lot of folks have said a lot of good things about you and a lot of positive impacts that you've made on their lives. You're not being sentenced to death. You won't be facing a firing squad or a gas chamber or electric chair. Your life goes on, but it'll go on behind bars, and you'll still have that same opportunity to make a positive impact on the lives of other people who you encounter, and I hope you do that. I simply cannot fathom a mother treating a child the way that you did and allowing that to happen to a child, to your child, the child that you birthed. Yeah. I don't know if the child at some point became a burden. I don't know what the circumstances were that would lead you to placing the child in that situation. And as if you left and went to Atlanta, Georgia, or maybe we'll say, not Charleston, to Myrtle Beach, and went there and got in the beach in the water a few hours, and then came back, and then decided that it's a frantic situation. You did it. You have to live with it. And as bad as the conduct of Mr. King was, yours was worse, in my mind. And, you know, you can talk about intent where you have rational thinking minds, but extreme recklessness brought upon by drugs and alcohol. As we said, intoxication is not a defense and not an excuse. That's what, in effect, you're asking, and it's not. Sentence of the court is that you be committed to the State Department of Correction for a period of 37 years on murder, 20 years on great bodily injury. Sentences will run concurrent, and you will receive credit for time served. Do we have the number of days of credit that they're entitled to?
Rita Pengalangan received a harsher sentence of 37 years for murder and 20 years for great bodily injury, also running concurrently. The judge told Rita that while her life would continue behind bars, she would have the opportunity to make a positive impact on others. However, he stated that he could not fathom how a mother could allow such harm to come to her daughter. In early 2024, allegations surfaced about a personal relationship between Fulton County District Attorney Fannie Willis and Special Prosecutor Nathan Wade, raising concerns over a potential conflict of interest in the election interference case against Donald Trump and his co-defendants. The controversy quickly escalated into legal challenges and hearings, leading to major changes in the case's prosecution. On January 8, 2024, attorneys representing Michael Roman, a co-defendant in the case, filed a motion to disqualify Willis from the proceedings. The motion accused Willis of engaging in a romantic relationship with Wade, whom she had appointed as special prosecutor in November 2021. The defense argued that this relationship could compromise the impartiality of the prosecution, as Wade had financially benefited from his appointment, raising questions about whether Willis had misused her authority. To address these claims, Fulton County Superior Court Judge Scott McAfee scheduled a hearing to review the evidence and determine whether Willis should be removed from the case. During the hearing, both Wade and Willis testified under oath about the nature and timeline of their relationship.
When did your romantic relationship with Miss Willis begin?
2022.
When in 2022?
Early 2022.
Wade admitted that his romantic relationship with Willis began in 2022, after he had already been appointed as special prosecutor. He denied that their relationship influenced his work and insisted that Willis did not financially benefit from their association. However, Wade faced intense scrutiny over inconsistencies in his past statements, particularly regarding his divorce proceedings.
Those were verified, so sworn under oath.
Mm-hmm.
Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right?
Mm-hmm.
Okay. In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
Okay. And you were actually held in willful contempt.
No, I'm going to object to the relevance of and
his credibility is relevant, Judge, and if he was held in willful contempt for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or commission or anything else on
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine if he's made misrepresentations in his pleadings. You're here to determine whether or not he's telling the truth or not. So if another court has held him in contempt, and that's part of the divorce proceeding, I think it's relevant.
But just contempt generally can be for many different things. Like failure to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
Your Honor, I object to the relevance of that. That's clearly not a proper impeachment. We're going pretty far afield into divorce matters that don't have any direct relevance to anything that's pending before the court. Subject to the relevance of that and need further exploration.
I'm not saying that they have other grounds for impeachment.
Let's talk about this December 22nd, 2023 verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that's an accurate read of the interrogatory.
To be precise, Ms. Gresham.
And you, please read it. I want to make sure I'm accurate. Please read it. This one actually has a number. I tabbed it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control, or any other person or entity, which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
Okay. And you answered that you did not have any documents to that effect, correct?
Correct.
And that was on December 22nd, 2023? You updated those responses again after the motion to disqualify was filed, then, correct?
When was the motion filed?
January 8th, 2024, when I filed the motion to disqualify you and alleged that you had a romantic relationship with Ms. Willis.
Yes,
After that, you updated these responses, correct?
yes, ma'am.
And so your new responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24.5.505, correct?
Yes, ma'am.
Okay. And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that, and then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Court records revealed that in his sworn interrogatories, Wade had initially denied having financial records related to a romantic relationship outside his marriage. However, after the motion to disqualify Willis was filed, he updated his legal responses and asserted privilege under Georgia law, instead of continuing to deny the existence of such documents. When questioned about these changes, Wade acknowledged that his answers had been revised after the disqualification motion was submitted, but maintained that his actions were legally permissible.
Office, it's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together anywhere?
No.
Never.
If there was a lunch that occurred that I just described, if there was a meal that occurred that I just described, anything outside of that, and it needs to be very clear. Not often. Once, twice. Because I want to be over-inclusive, I'm saying once or twice. I'm not certain that it happened, but I'd rather be over-inclusive with you.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
And well, no, look. I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
So my question was, do you have any problem?
I object to you getting any personal records of mine.
Willis took the stand and defended her conduct, emphasizing that her personal relationship had no impact on the prosecution and did not influence her professional decisions. She expressed frustration over the focus on her private life, arguing that the hearing should center on the charges against Trump and his co-defendants rather than her personal matters. On March 15th, 2024, Judge McAfee ruled that either Willis or Wade would need to withdraw from the case to eliminate any appearance of impropriety. While the judge did not find conclusive evidence of financial misconduct, he determined that their relationship created a potential conflict that could undermine public confidence in the prosecution. prosecution. Later that day, Wade resigned from his role as special prosecutor. Despite Wade's resignation, the defense continued to argue that Willis's involvement tainted the case. In December 2024, the Georgia Court of Appeals ruled that Willis should also be disqualified, citing the appearance of impropriety as justification for removing her from the case. This decision forced the appointment of a new prosecutor to oversee the ongoing case against Trump and his co-defendants. The disqualification of both Wade and Willis caused significant delays and complications in the election interference case. A new prosecutor was appointed by the Prosecuting Attorneys Council of Georgia to take over the proceedings. The situation sparked public debate over prosecutorial ethics, highlighting the challenges of maintaining trust in high-profile legal cases. As of early 2025, the case remains ongoing under new leadership, with Trump and his co-defendants still awaiting trial. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.